My office gets hundreds of calls a year from American employees who tell me that they took a stress leave from work and shortly thereafter they got written up or fired. Is that legal? The honest answer is it depends. In this video, I'm going to explain the legal protections, or lack thereof, available to employees suffering from stress. I'm going to explain why, for most people, it's a bad idea to take time off of work because of stress. And I will finish the video by explaining the circumstances when you are protected by law and when you should take time off to recover. My name is Branigan Robertson. I'm a California employment attorney. I'm making this video for workers all over America, but this is not legal advice. If you need legal advice, pick up the phone and call a lawyer in your state. If you're in California and you've been fired from your job, you can call my office for a free consultation. My contact info will pop up on the screen at the end of the video. Now, for whatever reason, it has become almost fashionable in our society to take time off of work because of stress. Now, I get it. Stress sucks. I dislike it as much as everyone else. My office gets calls every single week from people who took significant time off of work because of stress. Just this week, we got a call from a gal who was out of work for a year, an entire year, because of stress. And I hear reoccurring justifications for doing things like this that sound legitimate, such as I used FMLA, or sick leave, or a reasonable accommodation under the ADA. But do these laws actually protect people legally who take time off because of stress? Well, there is good news and bad news. And before I explain those, in your mind, you need to make a very clear distinction between stress alone and disabilities that result from stress. For example, you can be stressed out because your boss is a jerk or he gave you an impossible deadline. That is stress and stress alone. On the other hand, after dealing with certain types of stress, you could develop things like major depressive disorder, PTSD, or one of the many types of anxiety disorders. A disorder that is diagnosable is distinct and separate from the underlying stress that caused it. This is very important for you to understand, and it literally frames up the rest of the video. With all that out of the way, let's go get to the whiteboard and cover the bad news first. The main legal protections that apply to this subject are FMLA and the ADA. First, let's talk about the Family Medical Leave Act in the context of stress. This is the most common law that people cite to me that they think protects them. FMLA protects the job of employees who take a short leave of absence due to a serious health issue. If you qualify for protection under FMLA, you can take up to 12 weeks of leave. This can be taken all at once or over time in an intermittent fashion. And when the leave of absence is over, your employer is legally required to return you to work with the same pay, responsibilities, and benefits. However, stress and stress alone does not qualify as a serious health issue under this law. It will almost always fail to qualify unless it's diagnosed as a severe psychological condition, or it has led to a serious health issue or serious health condition. I'm going to talk more about this later. Next, let's talk about the ADA, or the Americans with Disabilities Act. The ADA says that it's unlawful for an employer to fire a disabled employee, that is, somebody who has a physical or mental health issue, so long as the employee can perform the essential functions of the job with a reasonable accommodation. Often, a short leave of absence can qualify as one of these reasonable accommodations. Under the ADA, transient or temporary emotional conditions, such as depression, anxiety, or stress, may be considered disabilities if they result from an actual psychological disorder or mental disorder, physiological or mental disorder, there we go, What does that mean? It means to qualify, it generally requires a diagnosis from a licensed physician or inpatient care, ongoing counseling, or a prescription of medication. In contrast to that, if the stress or anxiety is simply triggered by a personality conflict with your supervisor, or workplace politics, or due to the supervisor's standard oversight over your job performance, that does not establish a disability. Work is sometimes stressful. Just because you are stressed does not mean you're disabled. To be clear, stress may qualify as a disability so long as it results from an actual diagnosable mental disorder. But the main point I really want you to hear is that for the vast majority of people, and those who call my office, and when they say they took a leave of absence due to stress, they are not disabled under the definition of the ADA. Most people are just stressed out because of the workload, or their boss's personality, or some deadline, or whatever. What does all this mean? It means that most of the time when somebody takes time off of work due to stress, there is no legal requirement that the employer return you to work. That means they can legally fire you for taking the time off. Now, don't lose hope. There's a very big exception to this, which I'm going to cover here in a few minutes, so make sure you keep watching. Well, okay, if FMLA and the ADA don't protect people who need to take a leave of absence for stress, what about just using your PTO or your company-approved vacation time? What if you're just taking a day or two? Are you legally protected from being fired if you use one of these mechanisms? Again, it depends. Yes, you can take your accrued PTO for stress. Yes, you can use your company-approved vacation time for stress, but the employer is legally allowed to fire you for doing it. Now, don't get me wrong, they don't usually fire people for doing that, but they can. Because here's how it actually works in the real world. Most vacation and PTO plans at companies have an approval process. You have to give them notice, like 30 days, and your manager must rubber stamp your time off. But stress symptoms don't work like that. Stress is like the water behind a dam. It slowly builds day by day by day. The pressure keeps growing until the dam can no longer hold it back. And when the stress bursts through, it leads to a total meltdown and the employee can barely function. For most people, this is how they request a leave of absence. Everything suddenly becomes too much, they throw their hands up and they go on leave with almost zero notice to the company. Now, the obvious problem with doing this is that you can't just drop your work in the middle of an important assignment without serious consequences. Leaving work suddenly disrupts the workflow and slows down the completion of tasks, and it sometimes irrevocably harms the company. So if you have a breakdown like this, you throw your hands up and you say, "I'm going on PTO," like I've heard thousands of times, and you leave, the employer can fire you, not because of the stress, but because of the problem you created by leaving so suddenly. And this is an underappreciated point by people. They don't realize this, and they're always confused as to why they get fired after they go on a leave of absence. At the start of this video, I said that I think it's a bad idea for most people to take time off due to stress. And the reason I said that is because I speak with hundreds of people a year who take significant amounts of time off for stress. And in almost every single case, taking time off made things worse for the person, not better. And there are two big reasons for this. First, your stress is likely to get significantly worse, not go down. Stress at work usually grows because you're avoiding something. You're avoiding something difficult, like a big deadline, an angry client, a difficult boss, whatever. Taking a leave of absence, whether it's a day or a month, does not fix that difficult thing that you're avoiding. It just delays the problem and usually makes it worse. By going on a leave of absence for stress, you are usually just dumping the work on somebody else to get done. Moreover, by going on a stress leave, you usually don't become less stressed in that process. That stress just transforms into anxiety, and you're constantly worrying about what you're going to face when you return to work. There's a great saying, I think it's by Seneca, and it goes something like this: we suffer more often in imagination than reality. And my experience with stress proves that quote to be true. The sooner I got my butt in gear tackling the issue that I was avoiding, the more my stress levels went down. And usually when I finished the task that I had been dreading, I realized that the time I spent finishing the project was a fraction of the time that I had spent stressing about it. So my advice is just to do the hard thing, do it now, and get it over with. Second, in most situations, as I explained earlier, taking a significant leave of absence for stress is legally unprotected. The ADA and FMLA do not protect you for pure stress issues. That means your boss can fire you for leaving work. And if you think having a job is stressful, or you can't stand your boss, or whatever, imagine your stress levels. What are they going to be like when you suddenly have to look for a new job and you don't have any money to pay for food, housing, your kids, and all the other essentials? Personally, I'd rather have a stressful job than not have a job and be stressed about money. All right, I've covered a lot of bad news. Let's start getting into some of the good news, okay? We're going to start by talking about sick leave. The first thing you should know is that every state has their own sick leave laws. I'm obviously most familiar with California's sick leave laws, as this is where I practice law. Now, there are a lot of nuances to California's sick leave laws that I'm not going to get into here, but there are a few essentials that every employee should know. And if you're in a different state, you need to look up your state law on this issue before making any decisions. Better yet, call a lawyer in your state before making any decisions. Okay, California's law says at its basic level that if you've been employed at a company for at least 90 days, you are entitled to receive 5 days or 40 hours of paid sick leave per year. Sick leave is time off of work for preventative care, diagnosis, or treatment of an existing health condition. Additionally, you can use sick leave to assist a family member, like a child, a spouse, or a parent, who needs to get care, diagnosis, or treatment of an existing health condition. Obviously, the purpose of this law is to give everyday workers some short-term job security, right? When it comes to getting sick and getting treatment. The state of California does not want you to get fired simply because you had the flu and you were hugging the toilet for 3 days. Generally, if sick leave is planned, like if you had a scheduled doctor's appointment, you're supposed to notify the employer in advance before you go on leave. On the other hand, if you get sick suddenly, you don't have to give advance notice, obviously, but you do need to give notice to the company as soon as practical. So if you're hugging the toilet, text your boss, okay? Let them know. What about doctor's notes? Good question. In California, the employee does not need to get a doctor's note in advance of the leave, like to prove to HR that you actually have an appointment scheduled. Nor do you need to get a note to come back to work after using sick leave, like to prove that you were actually sick. And the most important part for our discussion today is that California law says that an employer may not discipline an employee for using their approved sick leave, for their accrued sick leave. So it's against the law for a company to punish an employee for taking their lawfully allowed sick leave. Again, every state has different laws on this leave, on sick leave. So if you're outside of California, you need to make sure you look up your state laws before making any decisions. But now that you understand the basics of sick leave and how it works, how does it apply to a health issue like stress? Yes, so long as you have the accrued time, you can take a few days off because of stress under the sick leave law. But there are two issues with this that you need to be aware of. Number one, this is only a short-term thing, right? It's limited to a maximum of 5 days per year. This is not the long-term solution that so many people call my office hoping for. And two, this doesn't solve the fundamental problem that we talked about earlier. Most people go on sick leave for stress with zero notice to the employer, dumping their work on somebody else or avoiding it until they return. And as such, the stress only gets worse while they're on sick leave, not better. So in all reality, do I recommend that people use their accrued sick leave for stress? No, I don't recommend that you do that. Now, you can do it, but I don't recommend it. The only time that I recommend somebody take time off of work for stress is when the stress has turned into a disability that is protected by law. That means the stress has caused an additional issue that is a protected disability or a protected serious health condition under the ADA or FMLA laws or one of the state equivalent laws. That means you have gone to a real doctor and you've been diagnosed with a real psychological disorder, or you've been admitted to inpatient care, or you're undergoing counseling, or you've been prescribed medication. You need to have a diagnosis from a licensed medical doctor, and your doctor is the one who is recommending that you take the leave of absence for a set period of time. In order to do this, you need to get a proper doctor's note to document this. The requested time off needs to have an end date, and that needs to be written on the doctor's note. And you need to submit that to HR and keep a record of all your communications with the company. If you don't qualify for FMLA, then you need to make sure that your leave is classified as a reasonable accommodation under the ADA type laws. I've made several videos in the past about reasonable accommodations, and I strongly recommend you watch them when you finish this one. Look, at the end of the day, if there's a legal dispute between you and your former employer, and the issue goes to trial, a jury of your peers is probably going to decide your case. Winning in front of a jury is hard, and you are going to need all the help you can get. Medical records are key to winning cases like this. You will not win in front of a jury by just saying, I was stressed out, right? The jury is not going to be sympathetic to that because they have all been stressed out in their own lives and they didn't take a leave of absence. So you need to do a very good job documenting the issues beyond the stress that caused the disability. Now that you understand the basics, I have a few video recommendations and you need to watch these videos. These videos will broaden your knowledge around this area of law so that you can act with confidence when you are having a health issue at work. There are 3 that you should watch immediately. Number 1, my video on FMLA, which gets into the details as to who qualifies and who does not. Number 2, my video on when HR must reasonably accommodate you under the ADA and state equivalent laws. And number 3, my video on how to properly request a reasonable accommodation. If this video was helpful, please give the video a thumbs up, hit the like button, subscribe to the channel. And if you've been fired from your job and you're in California and you think something unlawful happened, don't be afraid to give my office a call for a free consultation. My office helps people who got fired and they believe they have been wrongfully terminated. That's all I have for you. Have a great day.